Scotus Ruckus. Produced by InlexVeritas.com.
This is Lexi Toteberg, a reporter for Scotus Ruckus. Thank you for tuning in. With me is our legal analyst, Dave Weinstein. Thank you for coming in.
Thank you for having me.
Scotus Ruckus is a program dedicated to giving our viewers an in-depth look into the cases pending in the Supreme Court of the United States, through the lenses of the oral arguments. There will be virtual coverages of the oral arguments, spliced up with easy-to-understand legal analysis and explainers in between. Also, with me, via satellite is Vera Boehner, standing by at the virtual courtroom. Hi, Vera. How are you? Can you introduce our first case?
Hi, Lexi. Fine, thank you. Sure. Today's case is Spokeo, Incorporated versus Thomas Robbins. To put it bluntly, this is a case in which an individual is standing up against a corporation, petitioner, Spokeo, which engages in business of personal data aggregation on the Internet, personal data including those of that individual, respondent, Thomas Robbins. Spokeo, petitioner from the unfavorable ruling below at the Ninth Circuit, is defendant in the original suit brought on by plaintiff, Thomas Robbins, under certain sections of the Federal Credit Reporting Act, in the Federal District Court in California. While the parties seem to disagree on the actual questions presented here, petitioner's version is as follows. Whether Congress may confer Article 3 standing upon a plaintiff who suffers no concrete harm and who therefore could not otherwise invoke the jurisdiction of a federal court, by authorizing a private right of action based on a bare violation of a federal statute. Well, I think the oral argument is about to start, and let's listen in.
We'll hear argument next today in Case 13-1339, Spokeo versus Robbins. Mr. Pincus.
Thank you, Mr. Chief Justice, and may it please the Court. This Court has said that the irreducible constitutional minimum for standing is injury in fact, that the plaintiff suffered actual or imminent tangible harm. In Lujan, the Court said that Congress may elevate to the status of legally cognizable injuries concrete de facto injuries that were previously inadequate in law. Here, the Ninth Circuit held that there's no need for any de facto injury. A statutory violation that in some general sense relates to the plaintiff is all that's necessary, even though it has no tangible consequences.
Let's say I agree with you that there needs to be a concrete injury, that Congress needs to have recognized something that looks like a concrete injury. But why isn't that exactly what Congress did here? So let me just frame it in a hypothetical. Suppose that there's just a statute. It's a little bit of a simpler statute, and you can argue with me or tell me why it might or might not be different, but I just want to understand your position. Suppose that there's a statute that just says that one of these credit reporting agencies shall not disseminate inaccurate information about people, or shall not do it willfully or negligently or what have you, but shall not disseminate inaccurate information about people. And then there's a cause of action that says if they disseminate inaccurate information in a credit report about you, you can sue. All right? Is that enough of a concrete injury for you?
No, it's not, for three reasons, Your Honor. And let me preface my response by saying that, of course, that isn't the case with respect to three of the claims in this case, which don't have anything to do with inaccuracy.
Okay, but let me just focus on what seems to be the gravamen of the claim. And why isn't the dissemination of false information about you in a credit report, why isn't it perfectly sufficient if Congress says that's a concrete injury?
Well, I guess as a threshold matter, I think what the Court has said in other contexts is that Congress should clearly say that it is going beyond the tangible injuries that this Court has defined. The Court has had a clear statement rule. And so another difference between your hypothetical, I'm not sure whether your hypothetical has Congress clearly saying, and by the way, we are creating a cause of action for people who otherwise couldn't get into court.
I'm sorry.
Let me start. Well, maybe I can answer your
you
question
said
this
that
way.
There were reasons why that was not a concrete injury.
Yes.
The dissemination of false information about a particular person. Why? Because to me, I'll just say, seems like a concrete injury to me.
Well,
You know,
first of all,
I mean, if somebody did it to me, I'd feel harmed. And I think that if you went out on the street and you did a survey, most people would feel harmed. Most people would feel as though they had some interest that had been invaded. And Congress recognized that, thought it was a significant problem, passed a statute to deal with that problem.
first of all, the common law tradition, which the Court has looked to, did not say that the dissemination of any false statement was an injury. To prove defamation,
That's quite right. It's not completely in the common law tradition, but we've said many times that Congress gets to look beyond the common law tradition and gets to identify real-world problems out there in the world, harming people in real-world ways, and that, it seems, is what Congress did here.
well, let me answer your question in two ways. I want to explain why it isn't, and then I also want to explain why it's not what Congress did here. So why it isn't, there are places that the Court has looked for guides. One is the common law. Other kinds of torts, for example, in the restatement.
Can you explain the common law versus the legislature? So if we have some historic practice where damages are awarded to someone who has no out-of-pocket loss, if the common law says so, it's okay, but if Congress says so, it's not? It's very strange.
I don't think so, Your Honor. I think, well, this question takes me a little afield from Justice Kagan's question, but I think the common law had some very specific areas where it defined actual harm. For example, any intrusion on a property right is actual harm, but there has to be a property right for that to be so. So I think Congress could create a property right, and if it did that—
Sorry, you're saying, contrary to one citation, you're actually Asby versus White, that it isn't a right that Congress has given you?
Well, let's pause here for a little while. It's going back and forth with Mr. Andrew Pincus and Justice Elena Kagan. It's a bit confusing without the context. I think we need a little bit of civic lesson. First, you were telling me before this show that this case is all about standing. Dave, can you explain to us about standing? I imagine this is one of those hyper-technical legal terms, not used with ordinary meanings.
Sure. It does have a root in the ordinary usage, I believe, but you're right. This is a legalese that first-year law school students struggle with, as with most experienced lawyers. Literally, standing means a right to stand before the court to present your case, to have a day in court, as the proverbial saying goes. This concept of standing has existed in one form or another in common law jurisdiction even prior to the ratification of the Constitution. Finding no clear text in the Constitution, the courts on many occasions have superimposed the long-standing common law concept onto the judicial power over the cases, in law and equity, to controversies as set forth in Article 3 of the Constitution. Alternatively, the judiciary power as it pertains to cases and controversies under Article 3 has been interpreted against the background of this long-held common law concept of standing. In other words, the cases that are brought up in the federal courts must be of those cases or controversies within the meanings of Article 3 of the Constitution, which would have standing, otherwise the cases would be dropped due to lack of standing. Now, to unpack this, the court has set down 3 requirements to establish standing under Article 3 as follows. 1. Injury in fact that is concrete and particularized and actual or imminent. 2. Such injury fairly traceable to the challenged action. And 3. Such injury will likely be redressed by a favorable decision. I believe these requirements are well settled in the court's jurisprudence. To unpack these requirements further, the court is essentially saying we, the court, will be deciding who will be standing before us, and that no Congress nor President can tell us what to do about that. I mean, realistically speaking, not all yahoos can come into the court with the right to have a day in court. A kind of like a bouncer at a fashionable club in Manhattan, the court inevitably needs to filter some people out due to its restraint on resources. However, Congress has in the past enacted numerous laws giving people a right to sue, or in other words, a right to stand before the court under certain conditions. The legislation at issue in this case, the Federal Credit Reporting Act, is a good example. So, To accommodate this incursion by Congress, the court has carved out a few de facto exceptions to the above requirements. One is the statutory elevation of legally cognizable injuries, concrete, de facto injuries that were previously inadequate in law, as stated in the case of Lujan versus Defenders of Wildlife.
Thank you for that civic lesson. Okay. Having put away the context, let's see what Spokeo through its attorney, Mr. Andrew Pincus, a well-known member of the Supreme Court's bar in Washington, D.C., is really saying here. Dave, can you unpack this for us?
Mr. Pincus is basically saying, hey, we all agree that some form of tangible harm is required for standing. But, then, there is that exception of statutory elevation bit in Lujan case. Then, Mr. Pincus goes on, saying the Ninth Circuit held that there is no need for any de facto injury, which is an error. This characterization of the Ninth Circuit is a bit misleading without the full context of its opinion. Let's delve into the procedural posture of this case. People might have an impression that plaintiff, Thomas Robbins, sought after a lawyer to have his day in court, having been harmed in some way, including dissemination of false information about himself by Spokeo, Incorporated, which runs a personal data aggregator website. That probably is not true. More likely, the lawyers who brought the case on behalf of plaintiff was actively looking for an ideal plaintiff to bring a suit, possibly a multi-million-dollar class action down the line, under the certain sections of the Federal Credit Reporting Act, and it just happens to be that Thomas Robbins with his particular circumstances in life fit into the ideal mold of plaintiff.
Interesting. The case seems to be more about the lawyers than this person, Thomas Robbins. Then, how was the case initially brought up in the court?
The case was initially brought up in the Federal District Court in California, which dismissed the case for lack of standing. The lawyers for Thomas Robbins submitted an amended pleading, and then the District Court said okay with respect to standing. However, with an interlocutory appeal pending to the Court of Appeals in the Ninth Circuit, the District Court in an unusual move reversed itself upon reconsideration and said it's not okay with respect to standing. In other words, the plaintiff still lacked standing. On appeal, the Ninth Circuit said okay, that Mr. Robbins has standing after all, but its opinion is somewhat ambiguous as to how it arrived to that conclusion. Mr. Pincus on behalf of Spokeo argues that the Ninth Circuit held that there is no need for any de facto injury as long as there is a statutory violation as it relates to the plaintiff in some general sense.
A few minutes into making his case, Mr. Pincus is interrupted by Justice Kagan, which seems to be somewhat rude.
Well, Lexi, it was not like this, say, 50 years ago. Now, this kind of interruptions has become a de facto standard practice in oral argument before the Supreme Court. Here, Justice Kagan throws in a hypothetical, which also has become somewhat fashionable among the justices. Going back to the case at hand, the consensus at this point seems to be that the present case does not meet the traditional three-part requirement test, including concrete injury, but the exception of statutory elevation of legally cognizable right is at play here. However, in a broad sense, a concrete injury is one form or another is deemed to be still necessary for standing, regardless. So, Justice Kagan explains that Congress thought that dissemination of inaccurate information by credit reporting agencies leads to undesirable consequences and gave the Federal Credit Reporting Act provisions for a cause of action. So, Justice Kagan is asking under these circumstances, quote, is that enough of a concrete injury for you? And quote, in other words, she is asking, under these circumstances, is that enough of concrete injury for the standing requirement? By the way, this might be a banal point, but Justice Kagan says, when setting up her hypothetical, the following, quote, so let me just frame it in a hypothetical. Suppose that there is just a statute, it's a little bit of a simpler statute, and you can argue with me or tell me why it might or might not be different, but I just want to understand your position. End quote. This sounds a bit patronizing and condescending because Justice Kagan knows well that it is highly unlikely that Mr. Pincus would be given time to argue the finer points of her hypothetical. Also, after being fed with all the memos from her clerks about Spokeo's position, it is highly likely that Justice Kagan well understood Mr. Pincus's position.
Very interesting. It's like they are playing an insider game.
Yes. Oral arguments have become somewhat of a fast-paced game with a complex web of insider rules and meanings. In any event, Mr. Pincus tries to answer Justice Kagan's hypothetical question, quote, and why isn't the dissemination of false information about you in a credit report, why isn't it perfectly sufficient if Congress says that's a concrete injury? End quote. But Mr. Pincus struggles a bit and takes a sidestep by saying, I guess as a threshold matter, a phrase that sort of signifies an evasion of a direct answer. Then, Mr. Pincus goes into the method of analyzing the situation in which a piece of legislation encompasses a statutory elevation provision according to Lujan. Mr. Pincus seems to be saying that the following approach should be taken to analyze the statutory elevation situation. 1. Under the clear statement rule, the statute must clearly state that the statutory provision extends the previously defined tangible injuries. And 2. Look for analogies in the common law tradition, such as defamation. The common law tradition for the purposes of discussion here basically means court case precedents as opposed to statutes enacted by Congress. Mr. Pincus struggles to argue that the Federal Credit Reporting Act fails to create the statutory elevation since the statute is unclear as to identifying the dissemination of false statement as a concrete injury. Pointing to an example of defamation in the common law tradition, Mr. Pincus says nay to the proposition that the dissemination of any false statement was an injury in the common law tradition, with an emphasis on the word any. Nonetheless, Justice Kagan steals the stage by pushing on. As to the clear statement rule bit, Justice Kagan points to voluminous legislative history, and the statute, Federal Credit Reporting Act, itself to equate the dissemination of false statements of a concrete injury. As to the common law tradition, Justice Kagan says, quote, Congress gets to look beyond the common law tradition and gets to identify real-world problems out there in the world, harming people in real-world ways. And that, it seems, is what Congress did here. End quote. At this point, Justice Ruth Bader Ginsburg steps in by commenting that it's very strange to make such analogy of statute to common law. She says, quote, so if we have some historic practice where damages are awarded to someone who has no out-of-pocket loss, if the common law says so, it's okay, but if Congress says so, it's not, end quote.
I almost felt relieved that Justice Ginsburg stepped in here. I mean, this was like a duel between the lawyer and the justice. While the oral argument thus far has been completely dominated by Justice Kagan. Let's break here for now, and we will continue in part 2.